also the written arguments accept that.
I have also accepted with one caveat that severability is for setting aside, not for modifying, in the sense that if there are 5 claims.
Now you may proceed. Now you may proceed. In your
Yes, I'll bear, my lord, what is in your lordship's mind. Lord, kindly allow me to give a little history, my lord. I'll give the history. Thereafter, I'll show to your lordships, my lord, the provisions of other jurisdictions where the unicitral model law is followed by their respective legislatures. And there are 5 or 6 countries, which includes United Kingdom, France, Canada, United States, etc., where they have suitably tailored their respective legislations without not going by strictly the unicitral model law. And third, my lord, my submission would be, my lord, that what can be the contours of your lordship's examination on answering the questions whether there is a power of modification or not. Because, my lord, it is my respectful feeling also, my lord, that some judicial oversight is necessary even to boost the arbitration. Lord, right now the position is that even arbitral tribunals are aware that 34 is almost a needle of the eye test, and therefore virtually the award is going to be final. And therefore, my lord, situations sometimes arise that the parties are not satisfied for more than one reasons, and that, my lord, kind of acts as a deterrent in going for arbitration. So the government is also interested in solving the problem. The question is how and by whom. Lord, now, Lord, our arbitration goes back, and I'll not, Lord, say anything which is not relevant for answering the question before your lordships. Our arbitration statutory journey, my lord, is from 1899. Indian Arbitration Act 1899 was the first. The purpose of showing, my lord, 3 sets of legislations in India for arbitration is to show that whenever the statute intended that there has to be a power of what they call varying the award, which we, my lord, in other words, say modifying the award. Lord, they have stipulated not only the power, but the contingencies under which it can be exercised.
Yes.
Lord, please directly come to, and I can again, my lord, assure your lordships, I will not read the whole thing, my lord, but whole thing should be before your lordships, when your lordships examines the matter and decides it, my lord. While delivering the judgment, your lordships must have everything on the table. That's the purpose, my lord. My lord, kindly come to para 3 directly. My lord, this is Arbitration Act of 1899. My lord, at the outset, I must say one thing, my lord. In the written submissions of my learned friend, Mr. Gaurav Banerjee, my lord, I find a very interesting and a very apt, correct line, my lord, at the end. I'm sorry, my lord. Mr. Banerjee's submission ends with a very intelligent, very correct, and very interesting line that over intellectualization of arbitration is India is the real problem. That's what my lord he has said. My lord, I'll take care that I do not fall into that. My lord, that was, my lord, I am told, my lord, by my lord Justice Narasimha. He has said that, my lord, but I'll add over intellectualization of anything in anywhere, any part of the world is generally the problem. But now kindly see, my lord, page 3. This is what, my lord, the provisions were. My lord, your lordships are at page 3. Right side bottom is the pagination.
Yes.
Power to remit award. Lord, this is 1899 Act. The court may from time to time remit the award to the reconsideration of the arbitrators or an umpire. Where an award is remitted under subsection 1, the arbitrators or umpire shall, unless the court otherwise directs, to make a fresh award within 3 months. Lord, here there is no modification power, your lordship would mark. Lord, it comes in 14, which is widely construed by judgments, where an arbitrator or umpire has misconducted himself or an arbitration or award has been improperly procured, the court may set aside the award. So this again is power of setting aside, but improperly procured is very widely construed by various judgments. My lord, improperly procured would not mean, my lord, in the linguistic sense of the term, but it would mean that there was no valid arbitration, the contract was not valid, the arbitral tribunal has traveled beyond the scope of the reference, etc., etc. And my lord, I have cited judgments, my lord, how it was widely construed. These are all, my lord, British judgments, because 1899, my lord, we had the British regime in place. Now, your lordships may kindly come to page 4. In that, my lord, 1899 Act had one schedule appended to the Act, which provided that these provisions of the then existing Civil Procedure Code would be applicable. That is, my lord, at the foot, my lord, page 4. These are provisions of the second schedule, which, my lord, incorporates by reference the provisions of the Code of Civil Procedure 1908, where the award or matter referred to arbitration may be remitted. The court may remit the award. My lord, remission is not right now, your lordships, my lord, scope of examination. Therefore, I'll skip. Kindly see 15. Grounds for setting aside award. An award remitted under paragraph 14 becomes void on failure of the arbitrator or umpire to reconsider it. But no award shall be set aside except on one or following grounds: corruption or misconduct of the arbitrator or umpire. My lord, very bold ground, my lord, specifically raised, specifically provided, B, C, etc. Lord, your lordships are not concerned with the grounds, because what I am respectfully trying to, my lord, show is that the power was setting aside of the award. No variation, no modification, no change, whether for good reasons or otherwise. Now comes, my lord, our Act 1940, which, my lord, which is the predecessor Act to the present Act. Your lordships may directly come to page 6 now. Page 6. Lord, this held the field from 1940 to 1996.
Perhaps earlier, because there was an ordinance, there were a number of acts which came.
The 95 ordinance. But Act.
That makes no difference.
No, that doesn't make any difference, because 96 Act repeals this Act. So it continues, my lord. Lord, 14, I have, my lord, cited for completeness. Award to be signed and filed. Lord, your lordships need not read it. I'll just orally point out what the scheme was. Once an arbitral tribunal makes an award, it was directly not enforceable the way, my lord, we do it now. The arbitral tribunal was under a statutory obligation to place it before the competent court for its affirmation. And it became a decree of the court only when the arbitral award passes through that test, which is laid down in section 15 and 16. Nothing turns on that. That was the scheme. That it was not the moment award is passed, it didn't become the decree. It has to pass the scrutiny. But please see, my lord, section 15. The lordships have section 15. Power of the court to modify the award. The court may, by order, modify or correct an award where it appears that a part of the award is upon a matter not referred to arbitration, and such part can be separated from the other part and does not affect the decision on the matter referred. Well, two things: specific power of modification conferred, and second, the severability or separability consistently, my lord, runs through 40 Act, Unicitral, and our Act, which I'll show. Meaning thereby, if they are so intermingled that they cannot be separated or severed, then it cannot be modified. That was how, my lord, this statute was judicially examined and interpreted. where the award is imperfect in form or contains any obvious error which can be amended without affecting such decision. C, where the award contains a clerical mistake or an error arising from an accidental slip or omission. Now it is section 33. But it was a part of modification power of the court when the court is presented with an award for making it a decree of the court. So before making it a decree, there was a power of modification in 1948. Then 16, power to remit the award. The court may from time to time remit the award or any matter referred to arbitration to the arbitrators or umpire for reconsideration upon such terms as it thinks fit. Since the questions which are referred, my lord, does not pertain to power of remission, unless your lordship, my lord, would like me to assist, I may skip this. Because that your lordships are considering whether modification power exists or not. Power of remission, my lord, is retained to a limited extent even in the 1996.
If it has relevance, then you please address it. If you feel it may not be, some of the council may refer to the power to remit.
Let me, my lord, then point it out, my lord. Because remission would not include power of modification. Modification would mean without doing anything more, the 34 court itself modifies, changes, varies the awards. Not power of remand, that we find this lacuna, I send it back, you correct the remand. Right now we are concerned whether 34 court itself can modify, vary or change the award. But my lord, let me read 16. The court may from time to time remit the award or any matter referred to arbitration to the arbitrators or umpire for reconsideration upon such terms as it thinks fit. Where the award was left undetermined, any of the matters referred to arbitration, or where it determines any matter not referred to arbitration, and such matter cannot be separated without affecting the determination of the matters referred. So again, severability was, my lord, a part of the exercise of the power. D, where the award is so indefinite, so as to be incapable of execution. There may be such instances where it is so nobody can understand how to enforce it. While an objection to the legality of the award is apparent on the face of it. 2. Where an award is remitted under subsection 1, the court shall fix the time within which the arbitrator or umpire shall submit his decision to the court, provided that any time so fixed may be extended, etc. An award remitted under subsection 1 shall become void on failure of the arbitrator or umpire to reconsider it and submit his decision within the time fixed. Then, my lord, judgment in terms of the award. Now it becomes enforceable decree in eyes of law, where the court sees no cause to remit the award or any of the matters referred to arbitration for reconsideration or to set aside the award. The court shall, after the time for making an application to set aside the award has expired, or such application having been made after refusing it, proceed to pronounce judgment according to the award, and upon the judgment so pronounced, a decree shall follow, and no appeal shall lie from such decree except on the ground that it is in excess of or not otherwise in accordance with the award. Well, somewhat similar to section 37 of the present act was absent there. It was almost final except this limited, my lord, ground of appeal. My lord, 18, I am not touching power of court to pass interim award. Please see section 30, grounds for setting aside award. Again, the grounds were only for setting aside, not for modification. Modification was 15 different grounds. Grounds for setting aside an award. Award shall not be set aside except on one or more of the following grounds, namely, that the arbitrator or umpire has misconducted himself or the proceedings, that an award has been made after the issue of an order by the court superseding the arbitration or after arbitration proceedings have become invalid under Section 35, that an award has been improperly procured or is otherwise invalid. So this is peri materia 234 of the present regime, my lords. So thereafter, my lord, I have shown, my lord, that
also pari materia to Section 15 of the 1900 Act.
no, I beg your lordship's pardon.
You had read the provisions from CPC, which are incorporated in the earlier Act.
1899 Act.
1999 Act. So
1899 Act had an appendix, schedule appended to the Act.
this Section 30 is pari materia to Section 15, which was by incorporation in the 1949 Act.
Yes, yes, for setting aside, yes. Improperly procured, only two grounds are added. Award is made after the issuance of order of supersession. And yes, my lord, only one ground is added. Otherwise, your lordships are right. 14 of 1899 Act and 30 of 1940 Act is substantially the same with addition of one ground. My lords are right. Lord, thereafter, Lord, I have given for your lordship's assistance, Lord, how 1940 Act, which provided for modification power, was construed by the courts, by Indian courts, my lord. Obviously, my lord, it was an act applicable to India. But, my lord, for the time being, I may skip that, my lord. There are three judgments. Only, my lord, one judgment, if your lordships can read, and that too the highlighted part. My lord, I have highlighted so as not to read the entire thing, while quoting the entire thing and annexing the judgment in my compilation, so that I'm not, my lord, nobody says that this was not fully pointed. But for easy reference, my lord, please come to page 9 at the foot. Lord, this is Ashok Kashyap versus Sudha Vashisht. The purpose of remitting the award is to enable the arbitrator to reconsider the decision where the legality was connected with the decision as contained in the award. It must not relate to a matter which has no connection with the decision or decree. Therefore, in our opinion, there was no scope in facts and circumstances of the case of exercising its powers by the High Court under Section 15 of the Act and the powers under Section 151. Lord, that was a case where the court modified the award and remitted also. The court said this is not, it's a very narrowly tailored statutory provision. Now, my lords, comes the main part. Why?
Yes, please.
Yes. My lord, thereafter, after, my lord, when this was going on, and there was, my lord, a kind of a feeling amongst the legal fraternity and the judicial fraternity that something needs to be done for the purpose of changing, modifying, etc. of the Arbitration Act of 1940. The question was referred to the Law Commission of India. And, my lord, we have 76th report on Arbitration Act 1940 by the Law Commission of India, my lord, penned by my Lord Justice H.R. Khanna. But I'll read only few paragraphs which are relevant for present controversy. Volume 1, page 231. My lord, my volumes are bigger, but I am going to read few pages only. My lord, I cannot be selective in filing. The filing has to be the entire report, my lord. It cannot be selective.
Volume?
Volume 1, page 231. My lord, it starts at page 208. But I am taking your lordships only to chapter 5. because chapter 5 is proceedings in the court on an award. Rest is, my lord, duties of arbitrator, how other things needs to be tweaked, etc. My lord, page 251, I'm sorry, my lord, my copy is little not, my lord. It's 251, page 251. Right side top is the pagination. My lord Justice Sanjay Kumar gets 251. Para 5.1, thereafter I skip what is not relevant for the present controversy and my lord read what is relevant. After an arbitrator has, am I with your lordship?
Yes.
After an arbitrator has made his award, one of the parties must obtain a judgment in terms of the award. Indian law, as enacted in the Arbitration Act, does not allow a party to enforce the award as such. This position therefore necessarily requires the question, what are the possible alternatives open to the court when its aid is sought for the purpose of making a decree in terms of the award? It's not a challenge procedure. The award does not get finality unless it passes the muster of the court. And what are the available options before the court when such an award comes before it?
Normally, 33 would be filed and 17 will be taken up together with that. 17 is the stamp of decree.
Correct.
But whenever the award is filed
Under 40.
under the 40 Act,
Under section 14 of 40.
14 of the 40 Act,
Yes.
wherever the party wants a setting aside, if section 30 read with 33 objections would be filed.
Would be fine.
To be taken up, and on the ordering of the objection and depending on the result, 17 would follow.
Correct. It would be either made decree of the court, setting aside partly, rule of the court, setting aside partly, affirming partly, and for limited grounds, even modifying, because there is a power of modification. There was a power of modification. Now, my lord, come to last but third para, unnumbered para, the second situation. Lord, I'm skipping, my lord, what is not relevant for the present.
Yes.
The second situation is equally unobjectionable since the power to modify or correct the award is, in this case, linked up with an imperfection of form or an obvious error and can be exercised without affecting the decision on the matter referred. The situation where an award contains an obvious error is illustrated by a series of cases where the award was erroneously passed against the President of India, while it should have been passed against the Union of India. The third situation becomes necessary by reason of the fact that the award, because of clerical mistake or accidental slip or omission, does not reflect the true intention of the arbitrator. The common link underlying the three situations is the legislative policy of giving effect to the substance of arbitration and the award. It may be noted that section 15 corresponds to the Code of Civil Procedure 1908, second schedule para 12. There was no such provision in the Indian Act of 1899. It was followed by way of reference by incorporation. The schedule was annexed to the Act. Nor is there any such provision in the English Act. Under the English Act, the court has no power to alter or amend an award. It may be noted that even in India, no such provision was contained in the Code of 1882 in relation to the arbitration without intervention of the court, and therefore the court had no power to amend the award or remit it. It could either file the award or reject the application. In absence of such a provision, the court had either to set aside the award or to remit it. Hence, the need for a provision conferring power to modify the award. The present provision is a salutary one, and we have no change to recommend in section 15. Lord, section 15, your lordships would recall, is a power of modification of the award on the grounds mentioned therein, my lord. Then at the foot of the page, 5.7, it may be noted that in the Indian Arbitration Act of 1899, there was no limitation of the grounds for remission. 13.1 of that act was as follows. My lord, ground remission, my lord, your lordships are not right now considering. I'll not, my lord, go into that, my lords. Lord, if your lordships, my lord, would consider partial remission, etc., my lord, there is a detailed discussion by the Law Commission, my lord, at page 255. But since remission may perhaps not have the relevance, but since other side may, my lord, put it, therefore, for completeness, I may read para 5.14. The reconsideration under section 16 may be the whole award, or it may be of a particular question only. If the whole award is remitted, the effective award is the second one. But if only some of the matters are remitted, it becomes somewhat difficult to decide how far the first award remains effective. The question was discussed in a Calcutta case. The view was taken that unless the court gave a direction under section 16(1) to the effect that the award of the arbitrator should be limited to the matters remitted to him, the arbitrator can, in his second award, confirm or repeat what he had said in the first award. Then skip the remaining two para and kindly come to 5.17. We may now revert to the need for widening the scope of section 16, a matter which we have already discussed. It is to be noted that at present, when an award which is defective in matters of substance is received by a court, when the only alternatives open to the court are to remit the award or to set aside. Power to set aside the award, in contrast with the power of remission, is a drastic one, because the court may then supersede the reference and direct that agreement ceases to have an effect with respect to the difference referred. Such a drastic action may not always be in conformity with the intention of the parties. It may lead to unnecessary litigation and in some cases to injustice. If this approach is correct, the power to remit should be worded widely rather than narrowly. In fact, this power in the earlier Act, Indian Arbitration Act 1899, Section 13, was very wide, because Section 13(1) of that Act provided that the court may, from time to time, remit the award to the reconsideration of the arbitrators or an umpire. There was no further limitation as to the grounds of remission. In the English Act also, the power is expressed as a power to remit the matters referred or any of them without any restriction as to grounds. Now, my lord, this may perhaps not survive, because now much water has flown and this issue is also debated and discussed in Uncitral, my lord, which came out ultimately with the model law. But I don't think any other part of, my lord, this report would assist your lordships, my lord, or the other side, my lord. Either way, my lord, it would not be of much assistance. Now, kindly come back to my note, my lord. Now, my lord, I will show how the model arbitral uncitral law, uncitral or unicitral, both, my lord, words are in vogue, came into being, my lord. Because there were page 12
Of the note.
of the note. Lord, I may say there was a detailed exercise undertaken by the unicitral. Several working groups meetings took place. Several discussions took place. India also participated in discussion. Other countries also projected their respective difficulties in their domestic arbitrations, international arbitrations, etc. And keeping everything in mind, this unicitral model law was framed, leaving it open for the member states. When I say state in the international law parlance, member countries to adopt it fully, partially, or not to adopt it. Lord, kindly come to page 13, para 39. Lord, everything which we now see as Article 34 of unicitral and our Section 34 of the Act is essentially based on New York Convention. My lord, your lordships are aware, New York Convention was essentially for the purpose of enforcement of foreign awards. It did not provide for any challenge procedure, etc. But if it meets with the following conditions, a foreign award can be enforced in another country. My lord, that is Article 5, which I have quoted. My lord, this would be relevant because your lordship would find this reference subsequently when the unicitral model law is in the making. My lord, kindly see at the foot, para 39. before the UNCITRAL model law for domestic arbitration or international commercial arbitration, the only major international convention on the subject was New York Convention, which dealt with enforcement of foreign awards. Articles of the New York Convention provided the scenarios where the foreign award could be refused to be enforced. Something similar to 34, that if these are the grounds, we will not enforce it. Please read, Madam. Recognition and enforcement of the award may be refused at the request of the party against whom it is invoked, only if that party furnishes to the competent authority where the recognition and enforcement is sought prove that the parties to the agreement referred to in this article in Article 2 were under the law applicable to them under some incapacity. This is one of the ground, my lord, in 34. Just, my lord, as a side reference. Or the said agreement is not valid. Same again. Under the law to which the parties have subjected it to, or failing any indication thereon under the law of the country where the award was made, or B, the party against whom the award is invoked was not given proper notice of the appointment of arbitrator or arbitration proceedings, or was otherwise unable to present. This comes, my lord, in 34, Article 34 of UNCITRAL, which we follow under Section 34. Even incidentally, the section is also same. Number same. The award deals with a difference not contemplated by or not falling within the terms of submission to the arbitration. Well, that is terms of reference. Or it contains decisions on matters beyond the scope of submission to arbitration, provided that if the decisions on matters submitted to arbitration can be separated from those not so submitted. So severability was sine qua non. That part of the award which contains decision on matters submitted to the arbitration may be recognized and enforced. If it is not severable, the entire award will become unenforceable. This continues in 34. I'll show this. The composition of the arbitral authority or the arbitral procedure was not in accordance with the agreement of the parties, or failing such agreement was not in accordance with the law of the country where the arbitration took place, or the award has not yet become binding on the parties, or has been set aside or superseded by a competent authority of the court. My lord, two, we are not concerned. My lord, at this stage, my lord, a need was felt. But I'm not going into the history because that's not necessary. But this is the period of time where, my lord, these are late 50s, where inter-country trade and commerce became, my lord, the rule of the day. And therefore, the arbitration and more particularly the international disputes between one party in one country and another party in another country started growing. That required a global framework that you provide for one model law, because each country has their domestic arbitration laws which are at variance with each other. And therefore, my lord, the UNCITRAL was tasked with the functioning of preparing a model law which can be prepared as a model, and member countries can either with modification or without modification accept it in their respective parliamentary legislation, or they may choose not to. My lord, kindly take volume 2. Volume 2 again is big, but I am going to read only 7 to 8 pages, some paras from those pages. But I have to put complete working group minutes, my lord, so that your lordships have the fuller picture. Lord, please come to page 501. Lord, the effort starts from 1976. At para 49. Lord, this is the Asian African Legal Consultative Committee initiated the discussion with UNCITRAL. That's the limited purpose of my showing.
501.
But
Correct. 501.
501, para 49. My lord, this is Asian African Legal Consultative Committee. They initiated that UNICITRAL should now come up with a model framework, model law, which can be utilized by the other countries. The problems encountered are sometimes due to the fact. My lord, I'm sorry. My Lord Justice Sanjay Kumar has 501, para 14. And I'm not reading the whole, my lord. It discusses the need for having a common my lord, model law, but 49 is relevant. The problems encountered are sometimes due to the fact that 1958 convention, that is New York Convention, does not regulate certain issues. This has on occasions led to uncertainty about the applicable law, that is, in respect of the validity of arbitration agreement, and due to the disparity of national laws to different results. One possible way of important could be to attempt to reduce that disparity by recommending uniform rules which would take into account the specific features of international arbitration agreements and awards. That would be in conformity with the discernible trend of national restraint in international context. Kindly now, my lord, come to page 502 at 503. My lord, the Secretariat of UNCITRAL, my lord, prepares this note. Para 8, my lord. Para 8 at 503. I'm skipping something, my lord, your lordships can take it from me. Would not be relevant either for this side or that side. My lord, I am presenting everything in a neutral way. 8. Yet another reason is the divergence existing between frequently used arbitration rules and national laws. This is the area of concern expressed by AALCC, that is Asian African Legal Consultation Committee, in its recommendations. For example, some national laws restrict the power of parties to determine the applicable law. Some national laws do not recognize the competence of arbitral tribunal to decide about its own jurisdiction, or they provide for judicial control over the composition of the tribunal and sometimes even over the application of substantive law. Other laws establish certain nationality requirements for the arbitrators or require the award to be accompanied by a statement of reasons irrespective of any agreement by the parties to the contrary. It is suggested that an UNCITRAL model law on arbitral procedure would, if implemented at the national level, solve many of the problems referred to. It would also establish universal standards of fairness and would thus meet the concerns expressed in one of the proposals of AALCC. Moreover, such a model law would prevent some, if not all, of the difficulties detected in the survey on the application and interpretation of 1958 New York Convention. Finally, the elimination of certain local particularities in national laws. A model law would be relevant in the context of the proposal of ICC to limit the reasons for setting aside awards to the grounds for refusing recognition and enforcement specified in Article 5, paragraph 1. I read Article 5 of the New York Convention. This is the beginning where the thought process started that even if you give the power of setting aside, or you provide for a judicial oversight for setting aside, restrict it to the grounds referred to in 5. Therefore, I read 5 because that is the genesis, that is the foundation of this thought process. If the Commission were to agree with the above recommendation, it may wish to request the Secretary General to prepare an analytical compile. My lord, your lordships can skip that part, my lord. Now, please come to, my lord, the Secretary General now prepares a report on 14th of May 1981, which starts at page 401, but kindly come to 519. 519. Lord, I'm skipping the rest because that's not relevant. It's because UNICITRAL was for everything. What is contract? What is arbitrable contract? How tribunal will be framed? How tribunal will conduct itself? When the tribunal's jurisdiction would end, when it becomes functus officio, fees, etc., etc. We are concerned with The recourse after the award is passed. That is, my lord, this chapter at page 519. Therefore, my lord, I am not reading the rest. 519, your lordships get, my lord.
Yes.
Means of recourse. My lord, from here till date, it's not power of appeal, right of appeal, right of revision, right to seek change modification. The expression continues to be recourse, which is, my lord, in my submission, a neutral term. What is the recourse? Then whatever is the power given will be exercised. Appeal against arbitral award, 102. My lord, I am on para 102. The question whether an appeal may lie from the arbitral award is relevant to the question at what point of time an arbitral award obtains the authority of res judicata, as it is called in Article 24 of 1966 Strasbourg Uniform Law, or becomes binding on the parties, which is one of the conditions for the award to be enforceable under New York Convention. As regards appeal to any second instance arbitral tribunal, the answer seems simple. The model law should recognize any such appeal if agreed on by the parties, as is not uncommon in commodity arbitrations. But Lord, kindly pause here for a minute. My understanding is what the Secretary General is pointing out is there are arbitration agreements which provide for double-decker arbitration. If I lose arbitration once, the contract provides for an internal mechanism providing for an appeal remedy. It is that. There are two judgments of this.
Hindustan Copper.
Pardon?
Hindustan Copper.
Hindustan Copper. I recently
Two-tier arbitration.
Two-tier arbitration. I recently lost.
Central trade.
On the lighter side.
You recently know, he lost quite some time back. He's just implementing it still.
Yeah, 1 month back or so. Your lordships are right.
That is the execution.
Yeah,
There's
we
a
lost
judgment
much earlier.
upholding the two-tier arbitration.
I lost in 2000 something. Your lordships
There
are
was a
right.
conflict, it got resolved.
Only my presence was
Central
central trade. My presence was the final barrier.
But probably this is what is referring to is something different. What it is referring to is the law of arbitration as applicable.
But
Not to, look, this is not referring to the execution part. It is referring to the first stage itself, which is the law of arbitration agreement as applicable in the country or the seat of arbitration.
correct. Your lordships are right.
It's not referring to the enforceability part.
No. The law itself or the agreement itself provide for a two-tier arbitration, as my lord just.
No, even otherwise, the law will not, suppose, let's say, even in England, if I'm not mistaken, they have a concept, still have a concept where the award can be made rule of the court or degree of the court.
I will show the provisions in England. England have deviated from the ancestral.
They have still a provision where you can make it a degree of the court. Then it becomes, or like here, suppose the award is pronounced here. Then you can find, or the seat of arbitration or the law of arbitration as applicable is Indian law to arbitration agreements. Then 34 will lie here.
And 36 also simultaneous.
34 will lie here. It is decided. Then the principle of res judicata will apply. But suppose you want to execute it, say, now in country A, which is a signatory to the New York Convention, in country A, the party which is defending can take recourse to 48.
Correct. Even we, in international arbitration, we can take recourse too.
But till 34 is decided,
Correct.
possibly you can argue, you can't have that award enforceable in a foreign country.
Unless that country's arbitration law permits. For example, in an international commercial arbitration.
May not be because if we go by what is stated over here, that recourse, because till then it doesn't operate as res judicata. For res judicata, there has to be finality of proceedings.
Functus officio, the tribunal
There has to be finality of proceedings. As long the matter is sub judice, it's not res judicata.
The arbitral tribunal, the award is res judicata. The tribunal becomes
If
functus
the
officio.
award is under challenge and it is pending consideration of the appellate forum, say the appellate tribunal, or for that matter 34,
Correct.
it will not operate as res
As res judicata, but the tribunal would become functus officio. Therefore, that is also a discussion that while remitting what happens because the tribunal no longer exists. Therefore, the word used is to resume, that the court would direct the tribunal to resume the arbitration, not continue the arbitration because you have already become functus officio. Then, my lord, 103. The answer is more difficult, however, in respect of any appeal to the courts. My lord, this makes it clear that first was internal appeal under the agreement.
Let's be very clear. The appeals against an arbitral award is one chapter, which is one heading. The second heading, number 2, is remedies against leave or for enforcement. That's the execution part.
Correct.
So that's the first part deals with the appeals against arbitral tribunal, which can be to a appellate tribunal, arbitral tribunal, or maybe in form of appeals which are provided
In the law,
in the law of that country.
the statutory appeal of the domestic law.
Domestic.
But instead of 34, we possibly, hypothetically, could have provided for an appeal, first appeal, my lord, against the order of the, against the arbitral award. That's correct. My lord, we agree on this side, my lord, that it should have. Well, that's, my lord,
What should have?
one appeal of right, my lord, that judicial oversight over the arbitral tribunal, my lord, is a must. My
It
lord,
should not be one-step adjudication. It should not be one-step
my
adjudication.
lord, the logic, my lord, as explained.
Anyway, that's a different question.
That's not, we are not concerned. But the logic, my lord, given by several courts in several other countries is why there is limited jurisdiction to interfere. The reason is the party autonomy. It is the parties who have chosen that instead of going before the regular dispute redressal mechanisms in the form of civil courts, we will have our own system. There would be a tribunal which would be consist of the members selected by us, and therefore it should be final and binding. Then you cannot have the recourse to the same procedure which you wanted to avoid. I wanted to avoid civil suit, revision against interim orders, then first appeal, then second appeal, then 136, and therefore we entered into the agreement that we would have our own grievance redressal mechanism, and therefore minimalistic interference. That's followed the view of almost all jurisdictions in the world. So then 103. The answer is more difficult, however, in respect of any appeal to the courts. Such judicial review on the merits, at least on certain questions of law, is envisaged under some national laws. Yet, as illustrated by the recent change concerning the most prominent example of special case procedure under United Kingdom law, there is a clear trend toward further limiting the control function of the courts in the international context. This development is based on the same considerations as the trend to restrictively apply any public policy ground, and that is the realization of the specific features of international commercial arbitration. In particular, its limited connection to any given domestic legal system. It is suggested, therefore, that judicial control on the merits be limited to the utmost. There are, of course, certain minimum standards which any state wants to see observed, even in international arbitrations. However, these standards, which form part of its international ordre public, it's public policy, we have checked up. Now, my lord, kindly see the next title. Is it public policy? Public order, but in this context, public policy. There can't be a public order issue in an arbitration. Remedies against leave for enforcement, that is executor. My lord, we are not concerned with this, my lord, therefore I will skip it. Kindly come to, my lord, page 520, heading number 3, setting aside or annulment of award and similar procedures. Your lordship gets, my lord. The issues relating to setting aside or annulment of, my lord, this is the main title is means of recourse. First is appeal, second is enforcement, Now, third is setting aside procedure. The issues relating to setting aside or annulment of arbitral awards are amongst the most difficult ones to be settled in the model law. It is also submitted that the pertinent provisions to be drafted will have a decisive influence on the value of the model law as a legal regime exclusively geared to international arbitrators. Well, this is where, possibly, this is my personal feeling, we have missed in 1996. The discussion was to bring in committee amongst domestic laws, but this discussion was focused more on international commercial arbitrations, not domestic arbitrations. But be that as it may, we go by this. This is particularly true with regard to the grounds on which an application for setting aside an annulment of an award may be based. To some extent, it is also true that regard to the procedures envisaged under domestic laws, to start with the minor problem, that is the procedure, there is a great variety in national laws of different claims for attacking an award. It should be challenging an award. Not only for setting aside or sometimes treated separately annulment of the award, but also to other aims, that is suspension or reinstitution. The disparities extend to procedural particulars such as form, time limits, and competent authority. For the sake of uniformity, which would facilitate international practice as regards post-award stage, an attempt should be made to establish commonly acceptable procedures, in particular to provide for only one type of application and proceedings, probably to be called setting aside proceedings. This is where the first emphasis on setting aside comes. Lord, 109 your lordships can skip. 110. Ideally, one should aim at a list shorter than the one set forth in 1966 Strasbourg Uniform Law that would contain only those reasons on which recognition and enforcement may be refused under the New York Convention, which I read, my lord. This restrictive approach adopted in Article 9 of 61 European Convention for enforcement purposes would meet the concerns underlying the corresponding proposal of the International Chamber of Commerce, which is contained in the list of subject matters for possible inclusion in the future work program considered by the Commission at its 11th session. It would help to prevent that an international award falls victim to local particularities of law, although the cases at hand bears no substantive connection with that respective state. Rest your lordships can, my lord, consider skipping. Please come to, my lord, now page 522 at 556. My lord, this is the third session of the working group of UNCITRAL. My lord, it starts at 522, but 556 is, my lord, the relevant part. Now, my lord, it starts getting in shape, that what would be the shape. Lord, your lordship would find Roman 6, means of recourse. Your lordship gets, my lord?
Yes.
My lord justice going, sir. Appeal against arbitral award. Question number 1. Should the model law recognize any agreement by the parties that the arbitration award may be appealed before another arbitral tribunal? We are not concerned. This is for two-tier arbitration, but not relevant. Question number 2. Should the model law allow any appeal to a court for review of the award on merits apart from setting aside procedure considered in question 6.6? Please see 108. Divergent views were expressed as to whether this policy should be stated in the model law. The prevailing view was not to incorporate a provision to that effect. While the model law itself would then not contribute to unification, the hope was expressed that the above-mentioned trend would continue. Another view was that the model law should expressly exclude any court review of awards on the merits in order to further the above policy. A suggestion was made to consider including a provision according to which an award was final or had the effect of res judicata subject to certain conditions. For example, it was not contrary to ordre public. That is, my lord, I read as public policy. Lord, this is all that is relevant in this group, my lord, meeting. Then we come to fourth session, my lord, which starts at page 558. Your lordships may come to 560. My lord, I am leaving those parts which are not relevant for answering the present question. Page 560, my lord. Consideration of possible features of a draft model law on international commercial arbitration.
Yes.
Para 13. The working group decided to commence its work by considering the 4 questions prepared by the Secretariat which had not been discussed at the third session. Means of recourse, setting aside or annulment of award, and similar procedure. Question 6.6. Should the model law provide for only one type of action of attacking an award, that is, setting aside? Leaving aside here recourse against executor, that is for enforcement. But see question number 6 and 8. There was general agreement that the model law should streamline the various types of recourses against an arbitral award and should provide for only one type of action of attacking an award. However, it was observed that the acceptability of this approach may depend on the decision as to which arbitral award were international and therefore subject to this law, and that the position on this question may not be final. 6 to 7. If so, on what grounds should such an action be successful? For example, would it be acceptable to restrict the grounds to those listed in Article 5, Para 1A(d) and 2B of 1958 New York Convention, which I read, with a possible restriction of public policy ground to international public policy? This was suggested, not accepted eventually. There was a general agreement that a restrictive approach in listing the grounds for the setting aside of award should be adopted. Some doubt was expressed as to whether the reasons for setting aside needed to be restricted to those which are mentioned in 1958 New York Convention. However, the prevailing view was that the grounds for setting aside should be restricted to those listed in Article 5, Para 1A(d) and 2B of that convention. Then your lordships can skip, my lord, the rest.
This is all on the foreign-seated international commercial arbitration.
International commercial arbitration.
It eventually became a part of a model law which was open for every country to adopt, and with these logic and these reasonings, our country adopted. My lord, I'm reaching to that. It is, if I can say, bodily lifted, my lord. So therefore, this would be.
In 1961 itself, we had a Foreign Awards Recognition and Enforcement Act.
Yes, your lordships are right.
But we, today in part 1 in 34, the issue that is being referred, whether there could be modification, severance, how much of profit do you derive from these discussions?
All of this, when your lordship reaches Article 34 of UNCITRAL, which is bodily lifted in our section 34, word by word. Therefore, your lordships would get assistance what each word meant when Article 34 of UNCITRAL was drafted. Lord, now please come to the fifth session. It starts at page 593, but I'm directly going to 623.
623.
623, my lords. Lord, which eventually became Article 34 was first draft Article 40, like, my lord, we see in the Constituent Assembly debates. This is, my lord, 623, recourse against arbitral award, Article 40. No recourse against an arbitral award made under this law, whether or not rendered in the territory of this state. Lord, every state will have to fill up their name. May be made to a court except an action for setting aside in accordance with the provisions of Article 41. My lord, this is section 5 of our act, my lord. Kindly note this at this stage. My lord, our law, my lord, now says that except as provided under the Indian Arbitration and Conciliation Act, there will be no other recourse, meaning thereby 34 is exclusive if you want to challenge. Now kindly come to the next page, Article 41. My lord, this is the present day section 34 and present day Article 34 of UNCITRAL, the predecessor of, my lord, with modifications. An action for setting aside an arbitral award referred to in Article 40 may be brought before the court specified in Article 5 within 4 months from the date on which the party bringing that action has received the award in accordance with Article so-and-so. An arbitral award may be set aside only on one of the grounds on which recognition or enforcement may be refused under Article 37, para 1A, B, C, D, or 2, or on which an arbitrator may be challenged under Article 9.2. My lord, this again, or incorporation by reference, this New York Convention. The court may, where appropriate, please mark, set aside only a part of the award, provided that this part can be separated from the other parts of the award. But this is the minimalistic interference, that you can set aside either wholly or in part. Severability, but you can set aside. No modification up to here, my lord, that is the position. If the court sets aside the award, it may order that the arbitration proceedings continue for retrial of the case. Please mark the word continue. So meaning thereby, my lord, it contemplated a situation where the arbitral tribunal was not functus officio as yet. So it would continue. We have said resume. Nothing turns on that, but that is the distinction. Unless such measure is incompatible with a ground on which the award is set aside. Suppose bias of an arbitrator. But obviously, it can't be remitted back. But subsection 4 is with a modified form, our section 34(4). Power of remittance, not modification. Remitting back, power of remanding. Any decision by the court on an action for setting aside is subject to appeal within 3 months. Now, my lord, rest is not relevant. Now, please come to, my lord, the 6th session at page 663. Page 663, my lord, your lordship gets, my lord.
Yes.
An award made under this law may be set aside whether in whole or in part. So first, only power of setting aside, whole or part, on grounds on which the recognition and enforcement may be refused under Article so-and-so, on which an arbitrator may be challenged under Article so-and-so, my lord, the New York Convention. An application / action for setting aside may not be brought after 4 months. That's limitation. We are not concerned. Come to 3, my lord. This is like our 4, 34(4). The court, when asked to set aside an award, may also order, where appropriate, and if so requested by a party, that the arbitral proceedings be continued. Depending upon the reason for setting aside, procedural defect found by the court, this order may specify the matters to be considered by the arbitral tribunal and may contain other instructions concerning the composition of the arbitral tribunal or the conduct of the arbitral proceedings. A suggestion was made to widen the supervisory power of the court under Article 30 by adding to the list of grounds manifest injustice. What we may not call manifest arbitrariness. Here, manifest injustice. However, this suggestion was not adopted since it was considered as too vague and too broad And since most cases of such injustice would fall under the grounds listed in paragraph 1B and 2 of article so-and-so referred to in the article, the working group adopted the grounds as listed in para 1 of article 30, which corresponds to the reasons for refusal of recognition and enforcement under 1958 New York Convention. It was noted that the ground placed between square brackets was not needed if the working group would adopt the second alternative in so-and-so. Then come to para 3.
Where will we find this article 27, paragraphs 1B and 2?
That is the New York Convention. Just a minute. No, Lordship, give me a minute. Article, which article, your Lordships?
27. What is extracted there in para 1?
Page 659, my Lord.
Page 560.
659.
6.
Article 27, my Lords. This is what your Lordships, my Lord, desired to see. These are the grounds for setting aside. No, I'm sorry, these are the grounds for recognition under the New York Convention. They are adopted as grounds for setting aside.
Yes.
Very similar at one point.
Under our law, 34 provides for annulment. 48 provides for grounds on which a foreign award can be refused to be enforced. They were similar, my lord, till, my lord, our jurisprudence developed. My lord, may I read this, or, my lord,
Yes. Please continue.
Article 27, shall I read?
Let's look at this. No difference.
Your Lordship says. Lord, kindly come back to 664, paragraph 154. Divergent views were expressed as to whether para 3 should be retained. Under one view, the draft provision was useful in that it provided some guidance on procedural questions which were relevant in the case of remission. Under another view, the provision should be deleted since remission was not known in all legal systems, and in particular, the idea of orders or instructions to an arbitral tribunal was not acceptable. There should not be any remittance, which we have retained in 34(4). Under yet another view, the option of remission should be retained without the giving of orders or instructions as envisaged in the second sentence. It was stated in support that this device would allow, please mark, my lord, to cure a procedural defect without having to vacate the award. This is how it was intended, that remission for some procedural defect. Procedural defect, my lord, according to me, would mean, I'm sorry, my lord, 34, one of the ground is the party to the arbitration was not given sufficient notice. Procedural defect. One document as an evidence was taken by the arbitral tribunal behind the back of another party, and he didn't have an opportunity to meet with. Procedural defect. But again, remittance on merits was neither envisaged then nor envisaged now. I'll come to that, my lord, when I reach our section 34. Now, my lord, kindly come to page 688 at 717. Lord, this is 7th session. Seven one seven. Well, your lordships would find I have substantially curtailed, my lord, this thick volume, my lord. I am reading only that part which is relevant, my lord, but I must place, my lord, the entire thing. Now it becomes Article 34. This is for the first time. It gets the shape. Application for setting aside as exclusive recourse against arbitral award. The recourse to a court against an arbitral award made in the territory of the state under this law, this was the name to be filled by each country, may be made only by an application for setting aside in accordance with paragraph 2 and 3 of this article. An arbitral award may be set aside by the court specified in Article 6 only if My lord, these are the grounds which are by and large similar to eventually what became Article 34. Therefore, I am not reading it, my lord. I'll read the final part, my lord. Then 718 sub article 4, which is our 34(4) for remission, which again not required, my lord, to be gone into, because your lordships are examining power of the court to modify, not to remit. The court, instead of setting aside the award, may order where appropriate. Well, please mark the word where appropriate. Well, there are some judgments of British court which says that considering the nature of the defect which we found, we would not like that it goes before the same tribunal. In some cases, they constituted a fresh tribunal and remitted the matter, but that question is yet not finally decided whether the remission power can be used for creating a new arbitral tribunal for removing the defects. But as the law in India stands, it has to be before the same tribunal, because the word used is directing the tribunal to resume the proceedings. So meaning thereby the tribunal is functus officio, remains under a cloud, and is revived for the purpose of issues remitted. Now, my lord, the rest, kindly come to, my lord, now 720. As your lordship gets. As regards paragraph 4, the working group adopted the policy underlying that provision, since remission, though not known in all legal system, could be a useful device for curing procedural defects without having to set aside the award. It was noted that the word, instead of setting aside the award, was too felicitous, since it could be understood as upholding the validity of the award for the time during which the arbitral tribunal deal with the case remitted to it. It was also noted that it was misleading to speak of a continuation of arbitral proceedings, since these were terminated by the final award, and apart from that, regard should be had to the fact that the arbitral tribunal may have to repeat an earlier phase of the proceedings. Therefore, the word resume comes from. Remittance may mean, my lord, that you start de novo. The working group was agreed that the wording set forth above, para 127, would meet those concerns. So then your lordships may, my lord, come to page 930. My lord, this is analytical commentary. My lord, what is what, my lord, I have given in summary, page 14 onwards, my lord, in my written submissions. My lord, in the next volume, my lord. Page 930. Lord, I'm not reading it, but substantially, Article 34 of Ancestral Model Law